Appeal in the matter of Infrastructure Services Luxembourg Sarl and another versus Kingdom of Spain.
Yeah.
Good morning, Your Lordships.
Well, you all very wisely not warning your whips, or you appear to have warned all sorts of other things, but that's fine. Two things really. First of all, the court does get incredibly hot, especially with this number of people in it. I will ask the court staff if possibly my clerk can get get Wilf to turn the fan on over the wherever it is, the big thing, that thing, over lunch, please, so that we can try and cool it down. The other thing was that we've got 4 days to do 2 appeals. We, that is the court, felt that 1 day for Zimbabwe was cutting it a bit fine, and that 3 days for Spain was rather on the generous side. So how you divide up your time is really a matter for you, but at the end of the day, it's got to finish within 4 days, please. Okay. That is Mr. Ballack.
Thank you.
First off, as it were.
Thank you, my lords. We've
got live note, haven't we? So have we got live note? Or I think we have, haven't we? Yes. So we don't need to worry about taking full note of.
My lords, can I just add another housekeeping matter, if I may? The transcriber has, I think wisely, given how hot it gets, has asked if we could have a 5-10 minute mid-morning break. But I'm in your hands.
Well, we've sort of stopped doing that, but given the heat, that might be a bad idea. So if we say about 11:45, we'll take, but only 5 minutes, please, not 15, which is what it's tended to become. All right. Okay.
My lord, could I offer to the court, in case it's helpful, I've just made a map of the authorities bundles, showing what's in where.
Oh gosh.
Because I didn't find it very easy. I did it for myself, and I thought it might be ungenerous not to share.
Yeah, that's very
Thanks.
helpful. Thank you.
Okay, sorry. Can I give you? Yeah, no, of course. I'll pass a couple back.
Thank you. Well done. That's very helpful, Mr. Green. Thank you very much. Right.
My lord, thank you. Good morning, Your Lordships. My name is Tariq Baloch, and I appear for the Kingdom of Spain together with Dr. Karen Miles. The first and second respondents to this appeal, Infrastructure Services Luxembourg and Energia Termosolar, respectively, are represented by Mr. Patrick Green, King's Counsel, Mr. Andrew Stafford, King's Counsel, and Mr. Richard Clark. And I would describe both respondents as the ISL parties. In terms of the material before you, my lords, you should have a skeleton each from Spain and the ISL parties.
Yeah.
And one core bundle, which contains, among other documents, the order and judgment that is being appealed, at tabs 4 and 5 respectively, and the fully referenced skeletons at tabs 17 and 18. For my part, my lords, I've taken those skeletons out because I will be referring to them rather than taking the bundle each time. You should have one supplementary bundle. And my lords, you should have 9 bundles of legal authorities. Those are joint legal authorities, so they'll be referred to by both all the parties across the 2 appeals. I will just, for the purpose of my submissions, I would ask your lordships to also have at hand the skeletons filed in the Border Timbers appeal. I believe each party has filed 2 skeletons each. It's a principal skeleton and a supplementary skeleton on each side. My lords, a background to this case, including the overview of the relevant legal instruments, is set out in detail in Mr. Justice Fraser J. then was his judgment, paragraphs 11 to 38. The factual background is also set out in Spain Skeleton. For this reason, I'll keep my recitation of the relevant background brief. But it is this, that on 22nd November 2013, the ISL parties commenced arbitration against Spain under the Energy Charter Treaty, or the ECT as I will call it. and the 1965 Convention on the Settlement of Investment Disputes between states and nationals of other parties, or the ICSID Convention, as we all refer to it. The tribunal issued an award on 15th June 2018, granting the ISL parties 112 million euros. The award was subsequently rectified by the tribunal on 29th January 2019. That rectification resulted in the damages being reduced to 101 million euros. My references to the award, therefore, are to the rectified award. On 30th July 2021, Spain's application under Article 52.1 of the ICSID Convention to annul the award failed. On 29th June 2021, the ISL parties obtained an ex parte order from Mrs. Justice Cockrell for the recognition of the award under Section 1.2 of the Arbitration Act, Arbitration International Investment Disputes Act 1966, and I'll be referring to it as the 1966 Act. And that act implements the ICSID Convention into law. Mrs. Justice Cockrell's order can be found at tab 10 of the core bundle, to which I'll be referring to that core bundle quite frequently.
Yeah.
And on 28th April 2022, Spain applied to have that registration order set aside on the basis that Spain, A, was immune from the jurisdiction, adjudicative jurisdiction of the English court under Section 1 of the State Immunity Act, or the SIA as I will call it, and B, when seeking the registration order, the respondent did not give full and frank disclosure. On 24th May 2023, the judge rendered his judgment rejecting Spain's application on both grounds and affirming the registration order, and his judgment can be found at tab 5 of the core bundle and his order at tab 4. And on 25th July 2023, he refused Spain's application for permission to appeal his judgment based on the 3 grounds pertaining to his conclusion on the SIA. So his finding on full and frank was not appealed, or permission was not sought to appeal it. And his reasons for refusing permission to appeal, to which I will come shortly, can be found in tab 5 of the core bundle. And his order refusing permission is tab 8. On 8 August 2023, Spain renewed its application for permission to appeal based on the same 3 grounds as had been presented to the judge. And on 5th October 2023, Lord Justice Males granted Spain permission to appeal the judge's order and judgment based on the 3 grounds. My Lord, the grounds can be found in tab 1 of the core bundle. They are summarized at paragraph 7 of Spain's skeleton. My Lord, this case is about the application and operation of the SIA, and I thought it may be helpful to give a quick overview of the core provisions of the SIA so that the grounds can be put into context. My Lord, if I can invite your Lordships to turn to the SIA, it's in the first volume of the Legal Authorities, tab 4. My Lord, I know you will have this, but first, it's tab 4. Section 1.1 of the SIA sets out the rule that Spain has immunity from the jurisdiction of the UK courts, unless one of the exceptions in the SIA applies. The burden is on the ISL parties to prove one of the exceptions apply. This is all uncontroversial. Second, which exceptions apply will depend on the particular immunity at play. And there are 2 types of immunity granted by Section 1 of the SIA. That's immunity from the adjudicative jurisdiction and immunity from enforcement or execution jurisdiction. And this case, this was really very neatly summarized by Lord Diplock in Alcom and Columbia. We've quoted it in our skeleton, my Lords, at paragraph 16. In this case, it's about the adjudicative jurisdiction of this court, the first type of immunity. And the SIA is structured around these 2 immunities because sections 2 to 11 are exceptions to the adjudicative immunity, and elements of sections 13 to 14 deal with exceptions to the execution immunity, with section 12 of the SIA dealing with service. And as you know, my Lords, as I said, this case is about the adjudicative immunity. My Lord, the ISL parties rely on 2 exceptions to remove Spain's immunity. Section 2.2, which is a submission to jurisdiction by prior agreement, and Section 9, the valid arbitration agreement. My lords, against that background, Spain's case continues to be that as a result of the immunity it enjoys by operation of Section 1.1, the UK courts did not have jurisdiction to register and enforce the award against Spain, and that none of the exceptions to that immunity have been proven to remove Spain's immunity. And the award should not therefore have been registered, and the award order doing so should be set aside. The judge disagreed, holding that for the purposes of enforcement proceedings under the 1966 Act, the exceptions to immunity in the SIA did not even need to be established. And even if they did, the exceptions under Section 2.2 and 9 were satisfied here to remove Spain's immunity. And it is against that background that Spain advances the following 3 grounds. The first ground challenges the judge's finding that an ICSID award against Spain could be registered in this jurisdiction without the ISL parties establishing an exception to Spain's immunity from the court's adjudicative jurisdiction as required by Section 1.1 of the SIA. The second ground challenges the judge's finding that in becoming a party to Article 54 of the ICSID Convention and ECT Article 26, Spain submitted to the court's jurisdiction by prior written agreement under Section 2.2 of the SIA. The third ground challenges the judge's finding that pursuant to ECT Article 26 and the ICSID Convention, there was a valid arbitration agreement between the respondents and Spain such that Spain was not immune from the adjudicative jurisdiction of the court with respect to proceedings for the recognition of the award under Section 9.1 of the SIA. My lords, unless you tell me otherwise, I will be making my submissions in that order of each of those grounds. But before I do so, I wanted to make one brief comment about the other appeal before you, and from the judgment and order of Mrs. Justice Diaz in the Board of Timbers appeal, if I may call it that for short. Although Mrs. Justice Diaz came to the same conclusion as the judge, finding that states did not enjoy adjudicative immunity in respect of proceedings for the registration of ICSID awards under the 1966 Act, her reasons for doing so are materially different. Unlike the judge, her ladyship found that 1, Article 54 of the ICSID Convention was not a submission to jurisdiction under Section 2.2 of the SIA. 2, that Section 9 of the SIA was applicable to proceedings for registration and enforcement of ICSID awards under the 1966 Act. Rather, her decision was based on finding that the registration of ICSID awards under the 1966 Act did not engage the court's adjudicative jurisdiction, and therefore no question of immunity under the SIA even arose, because that was only triggered by the act of adjudication. If that is correct, my lords, it would also impact this case, since it would be an additional reason to those maintained by the ISL parties for why Spain cannot rely on the SIA. Zimbabwe has appealed Mrs. Justice Diaz's judgment and order, arguing that the act of registration under the 1966 Act is an act of adjudication, and her ladyship was wrong to hold otherwise. Spain agrees with Zimbabwe's arguments and will not comment further on them in the course of my submissions. We simply note here that Zimbabwe's appeal on this point is unopposed by the Border Timber and ISL respondents, signaling that they also agree that the act of registering an ICSID award is an act of adjudication. In addition, the Border Timber parties have sought to uphold the decision of her ladyship on a new ground, namely that registration under the 1966 Act is outside the SIA's temporal scope and therefore application. And if successful, it too, that ground would also impact Spain's case and be an additional reason for why the SIA does not apply. Again, my lords, Spain agrees with the reasons given by Zimbabwe as to why this temporal scope ground is wrong, and I will not be addressing it, therefore, in my submissions. My lords, that is all I wanted to say by way of introduction, and I now propose to move on to Spain's submissions on the first ground.
Yeah.
My lords, the first ground deals with the judge's shorter route, as he called it, by which he held that the court was obliged to register and recognize ICSID awards without establishing an exception to Spain's immunity under the SIA. And he reached this conclusion based on the Supreme Court decision Mica and Romania and his reading of the 1966 Act. Under this ground, I will also address the ISL parties' additional ground by which they say that the effect of the 1966 Act means that the exceptions in the SIA need not be established. Well, as I said earlier, Spain's cases that the adjudicative immunity it enjoys under 1.1 has not been removed by the two exceptions, sections 2 and 9, relied on by the ISL parties to remove that immunity. Hence, it challenges the order registering the award on the basis that the English courts do not have jurisdiction to register the award against Spain. The learned judge took the view that this challenge was precluded by Mica, and in order to understand, we would submit why he is wrong, his lordship is wrong, I want to take you through just a quick outline of the facts before moving on to his reasoning. My lords, in Mica on 17th October 2014, two Swedish award creditors obtained registration of an ICSID award against Romania under the 1966 Act. Romania sought to set aside the registration order, alternatively to stay enforcement of the registration order, and it is common ground that the application for setting aside was not based on immunity grounds. Rather, it was based on Romania's case that one, it had paid the award in full, and or two, that the payment of the award would breach Romania's state aid obligations. Mr. Justice Blair refused to set aside the registration order. Rather, he stayed enforcement of the award, pending proceedings in the EU challenging the EC's decision prohibiting payment of the award based on breach of state aid. So he also refused to grant security. And thereafter, in the Court of Appeal and the Supreme Court, Romania never challenged the decision not to set aside the registration order. Rather, the focus of the appeal was on the power to grant a stay and security. In the Supreme Court, the claimants argued that under ICSID and the 1966 Act, there is no power to grant a stay. And the Supreme Court held that the ICSID scheme and the 1966 Act meant that once an award has been authenticated, it may not be re-examined and should be enforced, and therefore a stay cannot be granted. And this was so even if a stay may have been justified if a domestic judgment was involved. Accordingly, the Supreme Court lifted the stay. It also held that doing so, lifting the stay that is, would not breach the UK's obligations under EU law. The UK's obligations under ICSID took priority as a matter of international law. My lord, those are the key facts in outline. I want to now move on, my lord, to taking you through the judge's reasoning based on Mica before explaining why his lordship was wrong. My lord, if your lordships can turn to the judgment, it's in tab 5 of the core bundle. Apologize for the cough, my lord. If your lordships can turn to bundle page 86, in paragraph 72 in particular. My lords, in this part of the judgment, his lordship is explaining what he called the shorter route to dismissing Spain's jurisdictional challenge. And in paragraph 72, he introduces Mica and why he believes it is important. We can read it together, my lords, and he says, the unanimous judgment of the Supreme Court was given by Lord Lloyd Jones, Lord Sales, and the following extract will make it clear to any reader of this judgment what the approach of the High Court should be when considering challenges of the type mounted by Spain in this case. This is a lengthy quotation, but because it incorporates and indeed anticipates so much of the argument mounted in this case by Spain, I have concluded that it is best to reproduce it in full. And as he says, as his lordship says, he then sets out a lengthy extract from the Mica judgment, and I will only take you through some of those extracts in order to explain what the conclusions his lordship drew from that judgment. If you move, my lords, if you look at the paragraph that he immediately quotes, which is paragraph 68 from Mica, the highlighting is the judge's own, and it is worth reading because it explains why he decided as he did. It reads, the provisions of the 1966 Act, this is from Mica, must be interpreted in the context of the ICSID Convention, and it should be presumed that Parliament, in enacting that legislation, intended that it should conform to the United Kingdom's treaty obligations. And it is a notable feature of the scheme of the ICSID Convention that once the authenticity of an award is established, a domestic court before which recognition is sought may not re-examine the award on its merits. Similarly, a domestic court may not refuse to enforce an authenticated ICSID award on the grounds of national or international public policy. In this respect, the ICSID Convention differs significantly from the New York Convention on the recognition and enforcement of foreign arbitral awards, 1958. The position, and I want to read the quote within the quote, is stated in this way by Professor Schroyer in his commentary on Article 54.1, that's Article 54.1 of the ICSID Convention. The system of review, and that's a quote within the quote, under the Convention is self-contained and does not permit any external review. This principle also extends to the stage of recognition and enforcement of ICSID awards. A domestic court or authority before which recognition and enforcement is sought is restricted to ascertaining the award's authenticity. It may not re-examine the ICSID tribunal's jurisdiction. It may not re-examine the award on the merits, nor may it examine the fairness and propriety of the proceedings before the ICSID tribunal. This is in contrast to non-ICSID awards. It carries on. My lord, just if you move to paragraph 73, I don't need to read that particular paragraph to you, other than for you to note, because of what I'm going to come to later, that Professor Schroyer looms large, not just in the Supreme Court's thinking, but also in his lordship's thinking in this case. My lord, then the judge refers to some more authorities before setting out his conclusion on the shorter of what he then called the first route, which is paragraph 79. And if I could invite your lordship to turn to that. I will just to read that together. The availability of defences to a foreign state faced with an application to register an arbitral award under the ICSID Convention is far narrower than those that would be available if an award were being enforced under the New York Convention. ICSID is a separate and standalone international convention with signatories far more numerous than the member states of the EU. The 1966 Act was separate legislation dealing specifically with such awards. Mica makes it clear that for an additional defence to be available to a state, it must not directly overlap with those grounds of challenge to an award which are specifically allocated to convention organs under Articles 50 to 52 of the Convention. Jurisdiction of the tribunal and matters covered in the annulment application are plainly within such areas allocated to such organs. They are exclusively allocated under the ICSID Convention to ICSID itself. Therefore, Spain has no ability to deploy such defences in this application. This is an undoubtedly more lengthy than ideal explanation of the first route to the answer on this issue, on this application. My lords, a pithy synthesis of his reasoning is also found in the reasons he gave for rejecting permission to appeal. And if I may invite your lordships to turn to that, that's at tab 6 in the same bundle. My lords, if you look at, your lordships will look at paragraph 5 of those reasons. The Supreme Court, in the recent decision in Mica in Romania, made it clear that challenges to jurisdiction under the ICSID Convention are reserved to the ICSID organs themselves, and defences of the type relied upon by Spain are not available. That decision binds the High Court, as it does the Court of Appeal, and therefore neither limb of CPR 5261A will be satisfied. The draft grounds of appeal proceed as though Mica had not been decided, or if it had, as though it did not apply. Both approaches are, with respect, wrong. And if you turn over, my lords, and just to repeat, the same three grounds were put before his lordship as they are before you. Ground one merely avoids or seeks to undermine Mica without grasping the central point, namely that the ratio of that case is clearly against Spain. Service is not a relevant argument. And then, my lords, you can see with the way his lordship has highlighted it, Mica looms large across his understanding of why those three grounds did not have any merit. My lords, there are multiple problems I would submit, lordships, with his lordship's reliance on Mica. First, my lords, to the extent that the judge in the passage I just read in his reasons appears to be suggesting that the type of defences, which is a phrase he uses even in the judgment, raised by Spain should have been raised before the ICSID organs, he is respectfully wrong. This is because challenges based on sovereign immunity under the SIA can only be heard by the UK courts and not an arbitral tribunal. Spain's case is based on sovereign immunity. It enjoys before the courts of this jurisdiction by virtue of the SIA. That could never be the subject of the arbitration. That is not applying the SIA or charged with determining whether Spain has immunity in this court. And I don't understand any of the parties to be, in this case, suggesting otherwise. And if authority was needed for that proposition, an uncontroversial proposition, you will find it at paragraph 33.2 of Spain's skeleton in footnote 31. The second, and more fundamentally, my lords, the judge erroneously assimilated Spain's challenge based on the SIA with defences, the phrase defences. And this is not just a grammatical or a phraseology debate, which he said were precluded by Mica. Conflating merits defences in the underlying arbitration with sovereign immunity challenges fundamentally misunderstands the nature of a challenge based on sovereign immunity. It also, respectfully, I would submit, misunderstands what their lordships were saying in Mica. And I can explain why by reference, to make it quicker, by reference to Spain's skeleton, my lords. If you could turn to that skeleton at paragraph 13 to 20. My lord, starting at paragraph 13, state immunity is not a self-imposed restriction on the court's jurisdiction, but a limitation imposed on the sovereignty of the UK pursuant to customary international law. It is so important that the court has a proactive duty under section 1.2 of the SIA to satisfy itself that it is not breaching another state's immunity, even if that state is not before it. That is what section 1.2 says. And only if the immunity is removed can the court take jurisdiction over the foreign state and adjudicate the merits of the case against it, including whatever defences have been raised. And my lords, a number of authorities have made that point. Again, to make it quick, I will take you through the quotes and the skeleton, but there is one authority I'd like to take you to direct, and that is the judgment, Lord Bingham's judgment in Jones and Ministry of Interior. You'll find that, my lords, in the second volume of the bundle of the joint authorities. At tab 27, that's bundle 2, tab 27. My lord, I invite your lordship to turn to page 917 of the bundle, page 917, and that's paragraph 33, but it's a continuation from the page before. My lord, in the statement that I just wanted to highlight was on page 917, where applicable, could you see that? Mm-hmm. Where applicable, state immunity is an absolute preliminary bar precluding any examination of the merits. The state is either immune from the jurisdiction of a foreign court or it is not. There is no halfway house and no scope for the exercise of discretion. And my lords, there are a number of similar statements collected in the skeleton which emphasize the same key point. If you turn back to Spain's skeleton and footnote 17, you see there the late Judge Crawford's in Brownlee's Principle of International Law, which I know, my lord, you will all be familiar with, the leading text in international law. There it says, state immunity is a procedural bar, not a substantive defense based on the state and functions of the state or officials in question. At footnote 20, you have the leading ICJ decision in jurisdictional immunities, Germany versus Italy, again saying a national court is required to determine whether or not a foreign state is entitled to immunity before it can hear the merits of the case before it. And as these extracts underscore, and we explain in our skeleton, the question of immunity under the SIA cannot be displaced and obliges a court to determine the immunity question first before engaging in the merits. And Spain submits, the Supreme Court of Mica does not say anything different. When it talks about merits, it's talking about the stage that comes after jurisdiction has been established. If we can turn back to the extracts of Mica in the judgment, my lords, and I'm sorry I'll be going back and forth. It's in tab 5 of the core bundle. Paragraph 72, my lords. And we just read those two extracts, and I just wanted you to keep them in mind, that it is, the first one being, it's a notable feature of the ICSID Convention that once the authenticity of the award is established, the domestic court before which recognition is sought may not re-examine the awards. It's limited to just authentication. That's what the Schroer extract says. The judge took those statements about not revisiting defenses and being limited to authenticating the award as indicating that the court could not do more, including assessing the immunity challenge raised by Spain under the SIA. But these passages in Mica are all speaking, we submit, of the stage when the preliminary bar on immunity has been negotiated. The merits question only arises once the immunity question has been determined. Those are the defenses. And the court will only authenticate an award once it has decided that the foreign state does not enjoy immunity. My lords, we know this to be true because, as I explained when I took you through the facts, the question of immunity was not even raised in Mica or considered by the Supreme Court. The court's jurisdiction to register the award and therefore exercise adjudicative jurisdiction over Romania was not being challenged on any of the grounds in sections 2 to 11. In fact, the court had taken adjudicative jurisdiction and cleared the preliminary bar when the above statements were made by the Supreme Court about what it could and could not do with registered awards. Its discussion necessarily involved only those issues that arose after the court takes jurisdiction on the basis that the immunity hurdle has been cleared.
I understand that your position is that the Supreme Court completely ignored the question of immunity, which they must have been aware of. So the whole discussion in Mica, they knew as they were undertaking that it could all be rendered irrelevant if a state actually asserted immunity.
Well, my lord, if I may, it's not that they were ignoring it, it was never raised. And it hasn't been raised until these cases.
But it didn't need to. The whole point about state immunity is that the court can raise it of its own motion. I mean, your submission assumes that the Supreme Court just didn't address the issue at all, didn't even think about it.
Well, my lord,
It
because
seems to me to be pretty unlikely.
my lord, the award had already been registered and made into a judgment. What was stayed was the enforcement, the next step of the judgment. So the Supreme Court didn't need to take the call. That call had already been made by Mr. Justice Blair in the first instance.
I know that, but,
Yeah.
but surely one would expect that the court would somewhere, if it so thought, have put in a caveat saying, of course, this is all on the assumption that the question of sovereign immunity has been addressed and overcome. And it is so fundamental. Your case is, as I understand it, that that awards against states, which ICSID is primarily concerned, can never be registered in the ordinary course if the state takes the point.
My Lord, can I just make a few points? The first point is that the ordinary course until these cases was that the SIA applied, and that when you looked at witness statements and applications, the assumption was that you had to prove an exception. My Lord, the second point is that it's not, at least from our end, my Lords, surprising that the Supreme Court would not make any statement about that, because as I'm about to show you, even Professor Schroyer understands that the ICSID Convention, which is all that they were concerned with, is about the merits, the defenses. It's not concerned with jurisdiction based on immunity. So these statements that they made, it does not necessarily strike one as odd for them to think, well, do I need to also clarify that this may undermine the immunity question, because that is a separate first stage inquiry. And as I've said, what the quotes show is that they are addressing the second stage. It's only if you think that there's some doubt as a Supreme Court looking at those quotes, thinking, well, do I need to clarify that defences here could mean immunity objections? And my Lords, I would submit that that's not what they thought, because it's pretty clear from the Supreme Court authorities, the quotes which I took you to, that defences are not immunity objections. But my Lord, if you are not convinced by that, can I just say this, that even if your Lordships take the view that somehow this case can stand for the proposition that immunity questions are, the SI does not have to be investigated because of Mica, because a point was not argued as a matter of precedent, it's not binding on you, and I'm going to come back to that. But can I just take you to Professor Schroyer's extracts, because it will show you that when he talks about being limited to authentication and defences, he understood that does not mean the inquiry into the immunity question is excluded. My Lord, can I then take you to those extracts? The first one is in Bundle 8, tab 123. Well, just on that, when your Lordship mentioned just another reason why the Supreme Court would not have had to ask the question, what about jurisdiction under the immunity? Romania was fully participating. It never challenged the immunity question. And that's another reason why it would not have struck the Supreme Court, as well as technically it understood, we submit, that defences can never be jurisdictional questions on the basis of immunity. Why it would not have felt the need to go ahead and say, well, this could impact immunity, and therefore we want to make clear that it doesn't or it does. But let me show you the Professor Schroyer extract, and that's at tab 123, page 3927. My Lords, this is Professor Schroyer's section on the ICSID Convention and immunities. And around halfway down in the left-hand column, you'll see the sentence starts, therefore. Do you see that? Yep. Therefore, the ICSID Convention on its own would not be a valid ground for withdrawing immunity in proceedings to enforce an award, but a combination of accepting submission to arbitration as a waiver of immunity and of the ICSID Convention as providing the necessary jurisdictional link to the forum state may achieve that result. If, by virtue of statutory provisions containing an arbitration exception, as we have here in the SIA, to immunity or a waiver clause accepting just submission to arbitration as an implicit waiver, immunity is denied in principle in respect of the country, then the general obligation contained in the ICSID Convention to enforce awards should overcome any lack of jurisdictional link to the forum state. Better still would be an explicit provision denying immunity for a foreign or international award has to be recognised and enforced in the foreign state. Well, that's one extract. Can I then take you to the book on ICSID Convention that he's written, where there's a briefer statement made And that's in the same bundle at tab 146. And it's page 4326. You see in paragraph 57, page 4326, the paragraph 57, you'll see, my lords, the provision on sovereign immunity from execution in Article 5 does not apply at the stage of recognition. Submission to arbitration may be seen as a waiver of immunity in proceedings to have the award recognized. My lord, he makes the same point here when he says that the way through immunity at the stage of recognition is the arbitration agreement, not Article 54 of the ICSID Convention. My lord, it is important to stress this because it's sometimes mistaken or confused in his lordship's judgment that we're appealing, that the arbitration agreement is not in the ICSID Convention, it's in the ECT. My lord, what these passages show is that Professor Schroyer also proceeded on the basis that the adjudicative immunity was not removed by the provisions of the ICSID Convention itself, such as Article 54. That is, his statements quoted in Mica about the court being limited to authenticating the award or not revisiting the merits and defences cannot be understood as excluding the inquiry into the court's adjudicative jurisdiction. This is because the Mica extracts, my lords, as I said, were about the effect of the ICSID Convention, and Article 54 in particular. Professor Schroyer rightly understood that the issue of state immunity was a separate preliminary question that was not covered by the ICSID Convention, but rather the arbitration agreement, which was a way through, which was seen as a way through the immunity question at the first stage. And as I said, this is why, at least in Spain's side, my lords, we find it remarkable to treat Mica as being a precedent for a legal proposition that the SIA regime was not applicable to ICSID registration proceedings. Quite remarkable, given that it was never argued or opined upon by the Supreme Court. But this should not be controversial as a matter of precedent, that is not binding on you. To the extent you need authority for that, can I quickly take you to the leading case of R. Cardim and the Brent London Borough Council? You'll find that in the second authorities bundle. Tab 20, my lord.
Tab. Sorry, which tab?
That's tab 20, my lord, of the second authorities bundle.
Yeah.
R. Cardim and Brent London Borough Council. Lord, and I wanted you to, your lordship, to look at paragraph 16. My lord, to paragraph 16, Lord Justice Buxton explains the nature of binding precedent, pointing out that it is not cases as such that bind, but their ratio, and I'm going to get this wrong, decidendi. He then adopts a test of cross, which may evoke all sorts of memories of the law of evidence at university. But the ratio decidendi in the quote of a case is any rule of law expressly or impliedly treated by the judge as a necessary step in reaching his conclusion, having regard to the line of reasoning adopted by him. As the next paragraph then shows, Lord Justice Buxton then applied the test to the facts before him and found that the assumption in the judgment he was considering was impliedly treated by the court as necessary to reaching his conclusion. But my lord, we submit that is not the case here. This is because inapplicability of the SIA to registration proceedings for ICSID awards was not a necessary step in the Supreme Court's conclusion that the stay on enforcement was precluded by the ICSID regime. Quite the opposite. Romania had submitted to the jurisdiction by a conduct, that is, it did not challenge the court's jurisdiction on the basis of immunity. And so the Supreme Court could not have had Romania's immunity in mind when it decided as it did. I'd simply add that at paragraph 33 of this same judgment, Lord Justice Buxton went on to explain that even an unargued proposition of law that is part of the ratio is not in general binding. You'll see that principle in paragraph 33. And we submit we are not in that territory because the proposition that the SIA does not apply to proceedings to register ICSID awards was not even part of the ratio. But even if it were, it would not be binding on you, my lords, given that no arguments were made on the issue. In short, even in that situation, given the importance of the SIA, we submit that deserves proper consideration in this case about its applicability or inapplicability in the SIA. One cannot just assume that the Mica, without the point ever being made or argued, is binding. So for all these reasons, we submit that Mica does not preclude this court from considering Spain's jurisdictional challenge based on the SIA. Rather, the situation is, as the Supreme Court have told us multiple times, the SIA is a complete code, and unless an exception is made out, the foreign state has immunity from adjudicative jurisdiction of the court of this country. My lords, I now come to the ISL party's argument that the 1966 Act itself removed adjudicative immunity of all contract states to the ICSID Convention with respect to actions in the English courts for the registration of ICSID awards against them. At paragraph 13 of their skeleton, the ISL parties say...
Before you move on,
Sorry.
can I just ask you this?
Yes.
When you were going through the judge's reasoning, and particularly paragraph 79, you said there were multiple problems with his reasoning. And as far as I thought you identified 2 reasons. Were there more?
Yes, my lord. Well, the third is a binding, because that submission was made, that it's not binding on him. Even if he thought that there was that it did represent the proposition of law, which he thought it did, it's not binding on him because it's not been argued for. So the first is jurisdictional questions based on immunity are not for an ICSID tribunal or an annulment committee. Secondly, it's not a defence, it's a preliminary bar. And thirdly, my lord, it's not binding in any event. As in, the second point is that Mica does not stand for the proposition he thought it did.
Yes,
And third, my lord, it's not binding. Yeah. My lord, if you look at paragraph 13, well, you don't have to look at it, but paragraph 13 of the ISL party say that the terms of the 1966 Act mean that you don't even need to look at the SIA and find an exception to Spain's immunity under Section 1.1. So it's another way of saying, as the Judge Mica did, that one does not even get to the SIA when it comes to proceedings involving the registration of ICSID awards. Now, the border timber parties also make this argument at paragraph 21 of their skeleton argument. That's the first skeleton they put forward. They say that the 1966 Act impliedly abrogates or created a statutory exception to state immunity in respect of applications to register ICSID awards. And this argument was made before the judge below, although it is not included in the judgment. It appears also to have been accepted by him, as his view that the SIA did not apply was based on both the SIA and the terms of the 1966 Act. My lords, both as a matter of history and interpretation of the SIA, Spain submits that it is wrong to say that the 1966 Act somehow abrogated or created a statutory exception to the SIA. My lords, let me start with the SIA itself. As you will see from Spain's skeleton at paragraph 26, the House of Lords and Supreme Court have explained that the SIA deals comprehensively with the jurisdiction of the courts on issues of immunity. It is meant to be a complete code, such that if the case does not apply to one of the exceptions, the state is immune. Added to this is the fact, as its long title explains, the SIA makes, I'm quoting now, new provision with respect to proceedings in the United Kingdom by or against other states, close quotes. Given these descriptions of the SIA as a comprehensive complete code designed to cover the field of immunities when it was introduced in 1978, it would require clear evidence that in fact enforcement proceedings or proceedings for the registration of ICSID awards were exempt from the application of the SIA, and that in fact the SIA was not a complete comprehensive code with respect to proceedings for the enforcement of ICSID awards. On the terms of the SIA, my lords, there is not even a hint that the 1966 Act was somehow exempt from the SIA's operation. In fact, the opposite is true, because in section 16 of the SIA, there is a list of proceedings under different statutes in section 16 to which the SIA does not apply. The 1966 Act is not listed there, it could easily have been. The 1966 Act itself was modified multiple times, including after the 1996 Arbitration Act was passed. My lords, when you look at the extract of the 1966 Act in bundles, we have made sure that the various amendments that were made to it post-66 are there. Again, my lords, no changes were then made to say or clarify that the SIA did not apply to the registration of awards under the 1966 Act. Spain believes that the SIA is clear on its terms, but based on Pepper and Hart, if your lordship believes that there is any doubt about the fact that the SIA applies to proceedings for the registration of ICSID awards, then recourse can be had to Hansard and the statement of the Solicitor General that speaks directly to the question of the applicability of the SIA to proceedings under the 1966 Act. I will first show you the extract, my lords, and then explain why it satisfies the test in Pepper and Hart, although I would submit it's obvious if you have any doubts. My lord, Hansard shows us, the extract that I'm about to show you shows us that the terms of the SIA were expressly modified to ensure compliance with the ICSID Convention so that enforcement of ICSID awards would not be blocked by immunity arguments. Clearly then, the drafters of the SIA believed that it did apply to registration and enforcement of ICSID awards. My lords, can I now take you to that extract? It's in Bundle 7, Authorities Bundle 7. Tab 121. Well, this is a Standing Committee D report on the state immunity bill as it was from 1978. And if you turn to page 3, bundle page 3856, there, my lords, at bundle page 3856, you'll see under clause 9, which then became section 9 of the SIA, what's called the arbitration exception. And we'll come to that in detail for the third ground. The debate at this stage, my lords, was the proposed amendment to get rid of the requirement in section 9 that it, as it was in the bill at that stage, that it only applied to arbitration in or according to the law of the UK. In other words, the bill at the time was limiting the arbitration exception to domestic awards or awards governed by English law. And the Solicitor General was advocating for the removal of that limitation because, as you see in the second column, it would mean, if you didn't remove it, that states would continue to enjoy immunity in relation to foreign arbitral awards. And he gave, as an express further reason for this removal, the obligation on the UK pursuant to Article 54 of the ICSID Convention. And you see that in the second full paragraph in that second column. There is an additional reason. Do you see that, my lords? There is an additional reason. I'm just reading it. Article 54 of the Convention on the Settlement of Investment Disputes between states, nationals and other states, which is to be found in the schedule to the 1966 Act, and then he quotes it, And then immediately below the quote, that convention deals with arbitration to which states are parties. There would thus appear to be a treaty obligation upon us to permit awards made under the convention to be enforced against such property. And by deleting the reference to the United Kingdom or its law, the amendment will ensure that a state has no immunity in respect of enforcement proceedings for any foreign arbitral award. My lords, Spain submits that that change was made precisely because, and it's a change that then translates into the Act as we know it today, precisely because Article 9 of the SIA was understood to also apply to proceedings for the registration of ICSID awards under the 1966 Act. So to the extent your lordships think that the SIA on its terms is not clear or raises doubts about whether the 1966 Act was a statutory exception, this Hansard extract clearly shows you a ministerial statement that is clear and unequivocally illustrating that the drafters believe that the SIA applied to proceedings for the registration of ICSID awards. And we submit that to the extent you get to the stage where you are not sure about whether the 1966 Act created a statutory exception, then Pepper and Hart would allow you to rely on this Hansard extract.
Well, what it shows, doesn't it, is it's recognised that the Act should not prevent the registration of ICSID awards.
Yes. Quite right, Mike.
I don't see how that passage that you just read has helped you in any way. It seems to me it helps Mr. Green. It makes it perfectly clear that ICSID awards are not included and weren't intended to be included.
Sorry, my lord, I don't understand. It's, my lord, section 9 is an exception to, if,
Yeah,
can I put it to you like this?
Which is making the point that ICSID awards are, if you like, a fortiori section 9 exceptions. That's why the Solicitor General wanted to delete the reference to the law of the United Kingdom, because otherwise we would have been in breach of our treaty obligations under the ICSID Treaty. And he's making the point that by deleting those words, you ensure that we are not in breach of our treaty obligations under the ICSID Treaty, because ICSID awards will be within section 9. That's the point he's making.
My lord, may I disagree respectfully? Can I say this? My lords, if Mr. Green Mr. Green's argument is you don't even get to the exceptions because there is already an exception in the 1966 Act. If that is what the Solicitor General thought, if that was what the law was, this debate would not have been necessary because ICSID awards were already taken care of because of the so-called statutory exception in the 1966 Act. So Spain submits that the reason why this amendment needed to occur is because the Solicitor General proceeded on the basis that the SIA and Section 9 does apply and it needs to be amended so that when you look at the exception and whether an ICSID award can be registered or not, you can say, well, ICSID awards fall within the scope of Section 9. Is there a valid arbitration agreement? The immunity has been removed.
So as I understand it, you say, well, this helps me on ground 1.
Yes.
Quite what the implications might be for ground 3 is another matter.
Right, quite right, my lord. My lord, this document is going to be referred to by Spain across all 3 grounds, but quite right, yes. My lord, because you see...
There's nothing in this part of the debate that deals with Section 2 or Clause 2 at all, is there?
Exactly, my lord. So that's my other point, which is, again, the Solicitor General...
Silencio, that your point succeeds because they didn't bother to debate it.
My lord,
They might have not debated it for all sorts of reasons, one of which might have been that it was blindingly obvious that if there was a submission to the jurisdiction, then none of this would arise.
Well, my lord, can I just, if I may, just come back to...
No, I'm not.
No.
I'm just to be honest, Mr. Ballock, I'm simply questioning whether any reference to Hansard is of any earthly use at all to your case.
Quite right, my lord. My lord, the paragraph 13 of my learned friend Skeleton says that if he is right on his interpretation of the 1966 Act, you do not even get to examine the exceptions. And what I submit, and it may be that I'm making the point, it's too high, your lordships can take it for what it is, but what I submit this extract shows is that certainly the Solicitor General proceeded on the basis that Section 9 does apply to ICSID awards, and as drafted at the time, it would have created difficulties and therefore needed to be amended. My lord, the Chancellor said, well, what about Section 2.2? Well, actually, quite right, my lord. That's the other point, and I'll come to it.
Yeah.
If there was a valid submission in the 1966 Act, that would have been another reason not to worry about what Section 9 said, because ICSID awards would get through on 54 in Section 2.2. But I'll come back to that, because this extract also helps on that.
Well, the wording used by the Solicitor General is that by deleting the reference, that will ensure that the state has no immunity. So one could read that as saying, well, we have a treaty obligation, so there cannot be immunity. And doing this will ensure that's clear. I'm not sure it takes you to the point of saying that the Solicitor General was recognising that absent that amendment, there would be immunity.
Well, he says that. He says that if without this, he says in that passage, if we don't make this amendment, foreign arbitral awards, states against whom there are foreign arbitral, they'll enjoy immunity.
I'm sorry, I haven't picked that up.
So if the clause remained unamended, if you look at the top of page 10, right-hand side, in respect to foreign states would continue to be immune. You see that at the top, my lord?
Yes.
Yeah. My lord, but what I'm also asking your lordships to keep in mind.
They'd agreed in writing to submit to the jurisdiction.
So if the clause remained unamended, states would continue to be immune from enforcement in respect of foreign awards or convention awards, even where they had agreed in writing to submit to the arbitration. So what he's saying is that those awards would not get through immunity because of the arbitration agreement, because as the bill stood at the time, it only applied to UK-linked awards. So you needed this amendment to remove that immunity.
Yes, he's not there talking about ICSID, is he?
He is, my lord, convention awards.
No.
I think he is talking about ICSID awards, my lord.
Is he?
Well, my lord, if you don't think...
Talking about the European Convention.
Well, it may be that it would encompass it, but then he goes on to make a specific point about ICSID, doesn't he? There's an additional reason. So
You're saying the additional...
What he's saying is that the reference to United Kingdom would cause a problem in avoiding in relation to arbitration awards which were of international nature.
You mean when he's talking about the convention deals from there is an additional reason downwards?
And then there's an additional reason in relation to ICSID.
Yes.
And that's because of the treaty obligation.
Treaty obligation. And he is saying, my lords, I will submit, that if we don't make this amendment,
Yes.
when someone comes to present an award, they will enjoy immunity. And what we want to be able to do is to change Section 9 because it applies to ICSID, I submit. Therefore, there will be an arbitration exception, which would mean that the immunity is removed.
Well, the words he uses are, will ensure that a state has no immunity.
My lord, you may say that as I understand your lordship to be saying, is that he was trying to make sure, rather than this being the only reason in which the immunity is removed.
Yes, because he's recognising that there is a treaty obligation. And so we must ensure that
Any foreign arbitral award
can be registered here.
He's talking about any foreign arbitral award, my lord. But when you combine that, my lord, also with the fact that the other statements I showed you about the SIA being a complete code, I would submit that together, what they show is that the SIA does apply and that an exception has to be proved. Because you see, as I said to you, my lords, what I am responding to on behalf of Spain is the argument that you do not even need to look at the SIA because of the 1966 Act.
I really do understand.
Yeah.
What I'm just trying to work out at the moment is to what extent you can draw from this support for your contention that there isn't just a blanket derogation from immunity because of the convention. So you have the Solicitor General pointing out there's a treaty obligation upon the United Kingdom to permit awards under the convention to be enforced.
My lord, can I put it to
Doesn't
you
seem like a very promising start.
My lord, can I put it to you like this, my lord? And I've already said that, so perhaps I'm repeating myself. I would submit that if Mr. Green is correct, this amendment would not have been necessary.
Well, it wouldn't have been necessary, but it might have been prudent.
My lord, in a context where there is absolutely zero evidence in writing anywhere that the 1966 Act produces an exception to the SIA, I would submit that even if you consider this not to be very strong evidence, it's, in that context, the best we have.
And seems to be the more interesting debate is over the fact that, on the face of it, if you're right, well, it may be in any event, we have conflicting acts of parliament. And what is the approach one takes to that?
Well, we submit that there is no conflict, and I will show you, because there is absolutely nothing in the 1966 Act. No one is pointing anything to it. It's more a contextual argument that is made about why the 1966 Act contains a statutory exception to immunity. And I'm coming to the basis on which my learned friend makes that argument.
The 1966 Act dealing with the convention, I mean, most awards under ICSID are going to be against states, aren't they?
Well, no, my lord. The operating assumption for that Act at the time was that it would be helping, and this I think is common ground, would be helping states sue investors, i.e. private individuals and entities. So the idea that it would...
The awards, the point is it's investors in foreign jurisdictions, and therefore, and this is the facts of this case demonstrate the very point. The facts of the two cases demonstrate the very point. You've got foreign investors, so far as respectively Spain and Zimbabwe are concerned, who were encouraged to invest in the foreign jurisdiction. And the whole point about the ICSID treaty was that the awards would be, by and large, not exclusively, but by and large, would be against the relevant foreign jurisdiction.
No, my lord, it's quite the opposite. The Travaux actually shows that the working assumption was that the awards under the ICSID Convention that would be coming out, and why they needed 54, was to allow for states to sue private investors. The investment treaty regime, out of which these two awards have come, is a more recent phenomena.
Well, you better show us that if that's the case.
My learned friend, and I will show you that, my learned friend, Mr. Moulan, will also be taking you to the Travaux in some detail where it shows that to be the case. And I will point you to the references in the skeleton. My lord, can I now go to the submission in more detail about why it is said the 1966 Act created an exception or contains an immunity and abrogates the SIA? My lord, for that argument to even get off the ground, it would have to be shown that in 1966, states could come to a prior agreement to submit to the jurisdiction of the UK courts in 1966. Because that's what the argument is. That the ICSID Convention contains a prior agreement to submit to the jurisdiction of all by all the states to the enforcing courts. Yet this was not understood to be possible until under the law prevailing in 1966. The ISL parties tried to argue otherwise based on what academic articles thought should have been possible in 1966, not what was in fact understood to be the law at the relevant time. And also I can take you to NML in Argentina. That's in the volume 3 of the authorities bundle. All right. So tab 33 of the third volume bundle. And I wanted to take you to page 1129 and paragraph 129. Page 1129.
Yeah.
Sorry for the transfer. It's volume 3 of the authorities bundle, tab 133.
Yeah.
Sorry, tab 33.
Tab 33.
Yeah. It's paragraph 121. My Lord, at paragraph 121, you see there the statement by Lord Collins as to the state of the law and immunity prior to 1978. It says, the position in English law prior to the enactment of of the 1978 Act was that it was thought that a prior contractual submission to the jurisdiction of the court was ineffective to amount to a waiver of immunity, and that nothing less than an appearance in the face of the court would suffice. In other words, the only way one could submit to the jurisdiction was to come to court when the proceeding started and say, I submit. It was not possible to agree to submit by prior agreement. Now, Lord Collins, in his subsequent paragraphs, then sets out the cases that articulate this rule of absolute immunity, as it's called, that would not be waived, that could not be waived by prior agreement. The cases are listed there, my lords: the 1924 case of Duff in Kelantan, the 1951 case of Kahan in Pakistan, which itself relied on Miguel and the Sultan of Johor, all cases that represented the law prevailing at the time of the 1966 Act. And then he elaborates on the cases in paragraphs 122 to 124. And my lord, it's in paragraph 125, he then summarizes the academic opinion, which criticizes as unprincipled the rule that immunity could only be waived in the face of the court. He also cites an article by Cohn from 1958, which argued that cases of Duff development in Kahan had overlooked the fact that submission in the face of the court was not the only form of valid submission, and that in 1920 the rules had allowed, the procedural rules had allowed for submission by prior contract. But this was just academic opinion. It did not represent what was understood to be the law, which Lord Collins had already summarized in paragraph 121. And this is why in his next paragraph, paragraph 126, he explains that section 2.2 of the SIA was designed to reverse the principle enunciated in Kahan that waivers by prior agreement were not permitted. And that was made necessary precisely because, my lords, irrespective of what the academics may have thought, the law prior to SIA was thought not to allow for waivers by prior agreement. And my lord, this is also confirmed by two sources we have added to the record. You will find them in footnote 44 of Spain's skeleton. It's a 1977 extract from Hallsbury and a 1973 extract of Dicey.
Sorry, where did you say we'd find them?
You would find that, my lords, in footnote 44 of Spain's skeleton.
Yes.
Both confirm, my lords, if you want me to take it to them, I can. I just thought for speed, I can just tell you what it says. And both confirm that the only way for a state to submit to the jurisdiction was to appear in the face of the court, and that submission by prior agreement was not possible. And also, I don't know if this was a moment you wanted to take a break, or I know you had indicated.
Yeah, we'll take a break now. So 5 minutes, please.
All rise, I think.
We'll just say the live stream will continue. This is a short
Can we
break.
possibly open the double doors so we get some circulation?
Yeah, he opened his laptop onto the microphone, so I couldn't hear anything. Sorry to be making faces at you. I just couldn't hear a word.
Hamza, do you want to do a test? Do you want? I've just moved it. Do you want us to do a test just to see if I can hear him? With all the other mics, okay. Sorry,
ice legs, get some water. And how are the water jets looking? Yes. To be fair, I'll just go and put some more in them anyway.
I'd suggest that.
You stand there, I'll go.
I'll get the door. Do you want me to get the
What time you sit? Yes, sir. Yeah, that's why we're getting them up there ready. I spoke to this one.
That's fine.
So you know what's going on. The judge is not.
Yeah.
All rise, people.
Is the court content for the doors to stay open a bit longer? Or would that be all right?
I've just been told by Bolton that the reason why the court wasn't cooled before we started is because it's the Court of Appeal, so it's listed in the Royal Courts of Justice courts list, not in the Rolls Building courts list, and therefore nobody knew that we were sitting here. Now you might ask that why somebody doesn't know when the Court of Appeal is sitting in the building, but that's a different issue that we needn't worry about. But I think what it means is, first of all, I've asked him to cool the court down over lunch with the sort of mega machine you saw that was here. I don't know what he's going to do with it. He's going to put it somewhere. I put it in the back, I think. but that makes far too much noise. So you can't hear counsel making submissions.
Should we have it turned off during submissions and just leave the
Well, I
doors
don't know which one's on. I mean, if
open?
there's
The one
one
at the back's on.
but that's
which is,
all right, because we can hear you.
I think maybe a bit noisier for the people at
Yeah,
the back
but,
than it
and
is
they're
for
going
the
to bring some
noisy.
fans as well. But I think for the rest of the hearing, I mean, tomorrow and Wednesday and Thursday, hopefully the court will have been cooled down before we start.
I was warned by someone who's appearing in a High Court trial in Court 11. They've also got such a machine. So anyway.
Well, you know, I've issued a practice note, as you know, hence the not wearing robes. You know, the thing has been reported in the Times law section some weeks ago. It's all over Twitter, but nobody does anything about it. We're told that the building management system will be replaced over the long vacation. Only a year later. Anyway, there we are. Yes, Mr. Barley.
Thank you, my lords. Can you hear me?
Yes, yes. No, we've had no problem hearing you.
My lords, where I left it was just at the NML judgment. And what I said was that despite the academic criticism, the law was thought to be that the only way to submit to the court was in the face of the court. And that is why Section 2.2 was drafted as it was, to allow for prior agreements, submission by prior agreement. My lord, just one more point on this. My learned friend tries to argue that the law in 1966 disallowed contract waivers but permitted those in a treaty. So he makes a distinction between the contract and treaty. The first difficulty, my lord, with that is that no case, book, or other authority supports such a distinction. And in paragraph 33, the ISL parties refer to a single sentence in the case of Miguel and Sultan Johor. My lord, you can look at that. Paragraph 33 of the ISL.
Sorry, which paragraph?
Paragraph 33, my lord. And it's highlighted by the ISL party. The point they're made is that the sovereign's immunity from jurisdiction of another sovereign's courts could be removed by treaty with that sovereign, avoiding the usual situation where any prior agreement by a state to submit to the jurisdiction of another state's court had to be affirmed in the teeth of the court itself. But when you read the facts of that case, my lord, it is apparent that the treaty being referred to did not remove his immunity. Rather, the case was about his status as a sovereign and whether his actions meant that that status was lost. The knock-on effect of losing that status would be a loss of immunity. So it was based on losing his sovereign status, not treaty submitting to the jurisdiction of the courts. The treaty did not speak to submission or waiver of immunity. And my lords, we know that this case continues to stand for the proposition which I said, which was at the time, the only way to submit to the jurisdiction was in the face of the court. And we know that because in NML, the case is cited for that proposition. And in fact, the judgment of Mr. Lord Justice Lopes is quoted there as saying that the only mode in which a sovereign can submit to the jurisdiction is by a submission in the face of the court, as, for example, by appearance to a writ. And that's quoted in Lord Collins' judgment, paragraph 1 and 2. Moreover, what the SIA did in section 2, my lord, shows why the distinction between the contract and treaty submission point does not work either, I would submit. Article 17.2, my lord, I haven't taken you to it, but perhaps I should, so you can have look at it. It's in the first bundle, tab 4. 1, tab 4. Your lordships can turn to 17.2. I don't know if your lordships have it. Article 17.2 shows that the agreement in 2.2 can be in a treaty, convention, or other international agreement. It is not just confined to contractual submissions. And Section 2.2 was needed to cover prior agreements by treaty as well, precisely because, contrary to the ISL party submissions before the SIA, it was not possible to submit, that I showed you, to the jurisdiction of this court by way of an agreement in a treaty. To underscore that, we can look at Section 23(3)(a) of the same statute, my lord. Turn to that. This will also be the focus in the Zimbabwe appeal, but I'm not going to address it on the temporal scope. I just want to make this point. 23(3)(a) says that 2.2 did not apply to prior agreements entered into before the SIA came into effect. That provision was designed to give certainty to states who had arranged their affairs on the pre-SIA basis, sorry for the inelegant phrase, when pre-agreed submissions were not permitted. This would not have been necessary, we submit, so far as agreements and treaties were concerned, if, as the ISL parties assert, it was already the case that prior to the SIA, states were permitted to submit to the jurisdiction via prior agreement or in a treaty. So we see, therefore, my lord, that the foundational premise of the respondent's argument on the effect of the 1966 Act we submit is not correct. A foreign state could not be deemed to have submitted to a jurisdiction of the English courts via treaty, such as the English ICSID Convention prior to the 1978 Act and the passage of the SIA. My lord, those were my submissions on the first ground. I now propose to move to the second ground, unless your lordships have any questions.
Yeah.
My lord, the second ground of appeal is that the learned judge wrongly decided that Article 54 of the ICSID Convention is a submission to jurisdiction under Section 2.2 of the SIA. My lord, it's worth, when I go through each of these grounds, to just show you the wording of that provision, Section 2.2. Your lordships have it open. I'd be grateful if you could look at it, of the SIA. Volume 1, tab 4. Well, before I go on to why we submit that his lordship was wrong on his conclusion on 2.2, can I just emphasize what 2.2 says on its face? The provision does not speak of waiver, but a submission to jurisdiction. That's also the heading. The significance of that you'll see as we move along, as I make my submissions. Sometimes waiver and submission are used interchangeably. Section 2.2 addresses a situation where the state submits to the jurisdiction by way of a prior written agreement. And the words after the semicolon in 2.2a tell you that merely specifying that the agreement is governed by UK law is not enough to be regarded as a qualifying submission. And the ISL parties say that Article 54 of the ICSID Convention constitutes a qualifying waiver under Section 2.2 of the SIA. And the judge agreed with them. My lord, it's worth now, if I may, to invite you to look at Article 54, given it looms large in this ground. It's in the 7th, Authority Bundle 7, tab 100.
Well, we can look at it most conveniently as scheduled to the 66 Act.
You can, my lord.
Page 41, it's in the same bundle as the State Immunity
Thank you, my
Act.
lord. Every time I think I'm being efficient in my referencing, I'm shown not to be, so I apologize for that. You are absolutely wrong. My lord, I'd ask you to read 54.1 especially. That each contracting state shall recognize an award rendered pursuant to this convention as binding and enforce the pecuniary obligations imposed by that award within its territories as if it were a final judgment of a court in that state. A contracting state with a federal constitution may enforce such an award in or through its federal courts. And may provide that such courts shall treat the award as if it were a final judgment of the court of such a state. With there, you can also read two parties seeking recognition or enforcement in the territories of the contracting state shall furnish a competent court or other authority with such state shall have designated for this purpose a copy of the award certified by the Secretary General. And then 3 speaks about the execution of the award. My Lord, I think I would submit to you, my Lords, that it is helpful before we get to Spain's submissions to at least understand how both respondents read the submission to jurisdiction in Article 54(1) and 2. Can I start with the ISL parties? If you turn to paragraph 41B of their skeleton, and it's at the top. If you turn over to page 40, the bundle page 409, it starts at B and it carries over. Under Article 54(1), I'm just reading from their skeleton, each contracting state is obliged to recognise an award as binding and agrees to enforce it as if it were a final judgment of its own course. The UK has accordingly agreed with the other contracting states that it will recognise any convention award as if it were a judgment of its own domestic court. Spain has consented to the UK doing so and agreed with all contracting states, including the UK, that this is the UK's obligation. And in so doing, my Lords, in so doing, all contracting states submit to each other's jurisdiction for the specific and limited purpose of recognition of ICSID awards. Now, the first 2 sentences accurately describe what Article 54(1) says in terms, that each contracting state has agreed to recognise an award as if it was a judgment of its own court. The final sentence, using the words "in so doing," is what the ISL parties say necessarily follows from the first 2 sentences, namely that each contracting state has submitted to each other's jurisdiction for enforcement purposes. My Lord, the same deductive reasoning, I've not been able to come up with a better word, but I'm trying to use a neutral word that isn't implied or expressed, but the same deductive reasoning is followed by the border timber parties. And if you turn to paragraph 20 of their skeleton, it's the supplementary skeleton, I apologize.
The supplementary
Skeleton of the border timber party.
Sorry, I didn't keep up with the paragraph number.
Apologies, my Lord, it's my fault. It's paragraph 20 of the supplementary skeleton of the border timber party.
Yeah, thank you very much.
And it was filed earlier this month on 5th June. Again, my Lord, it repays attention to read it together. And I'm about to do that. It will immediately be apparent that by signing up to the ICSID Convention, contracting states mutually agree to a regime that requires them to recognise and enforce ICSID awards as if they were final domestic judgments, 54(1), which is to occur through the domestic court or other authority designated for the purpose, 54(2). And then, my Lord, this is it. Inherent in this arrangement is an acceptance by each contracting state that if an ICSID award is made against it, then every other contracting state may, and then in brackets indeed must, exercise adjudicative jurisdiction over it for the purposes of recognising and enforcing that award. And then any other conclusion would fatally undermine the enforcement regime that Article 54 was intended to create. My Lord, just one more reference, paragraph 30.2 of the same skeleton. makes the same point about inconsistency with the contracting state's enforcement obligations. You see, my lord, the last sentence, unsurprisingly, there was no mention in this connection of states having any adjudicative immunity, which would have been inconsistent with such enforcement obligations. It's picking up the same theme, that it must necessarily follow more 54.1 and 2 say that there has been a submission to jurisdiction. Now, like the ISL parties, the Border Timber parties begin in the first two sentences of paragraph 20 by accurately describing what 54.1 and 2 say, and then say inherent in those provisions is that each contracting state must have submitted to the jurisdiction. Now, both parties therefore rely on the logic that having undertaken to treat awards as binding and final judgments, it must follow or is inherent in Article 54 that the states against whom the award is rendered have submitted to the jurisdiction for enforcement. Otherwise, it would undermine or be inconsistent with Article 54. Both ISL parties and Border Timber parties say that such deductive reasoning constitutes an express submission. They accept that a qualifying submission under 2.2 must be express. Spain says, as does Zimbabwe, that what both respondents are doing is in fact reading in and implying a submission to jurisdiction into Article 54. That is the core battleground. That is the essence of the dispute. Is it expressed or implied? My lord, I will structure my submission on this ground in 4 parts. I will begin by taking you through the relevant cases from this jurisdiction that elaborate on what qualifies as a relevant submission for the purposes of Section 2.2. What I intend to show you is that these cases cannot be dismissed as being of limited relevance, as His Lordship, Justice Fraser J has described them. These cases show the requirements for a qualifying submission are strict and will not be satisfied by the sort of deductive reasoning advocated by the respondents and accepted by His Lordship. I will then take you through Article 54 and explain why it does not meet the requirements for a valid submission under English law or international law. And based on this analysis, I will then explain why His Lordship was wrong to conclude that Spain, through Article 54, had submitted to this jurisdiction for the purposes of Section 2.2.
Can I just understand your argument? The convention or treaty is an agreement. Is that right?
It's an agreement between the contracting states, yes.
An agreement between the contracting states.
Yes.
So what Article 44 represents is a term of that agreement.
You mean 54, my lord? Sorry,
Article 54.
Yes.
It's a term of that agreement.
Yeah.
So all contracting states are agreeing with each other that each contracting state shall recognise an award rendered.
Right, yes, my lord.
So one of those contracting states is Spain. Spain agrees that the United Kingdom shall recognise an award.
Right.
So why has it not expressly agreed to that?
My lord, so as I will show you, my lord, what we are talking about is, what we are asking you, inviting you to do, is to set a test for what, well, we think it's clear, but to set a test for what is a valid submission to jurisdiction. And that goes beyond just what's in an ICSID convention. I say that because an implied waiver, which is what this is not enough.
Why is it implied?
Well, my lord, I'm going to show you why it's implied because, my lord, as the cases show us, even if this agreement had said Spain waives its immunity, it would not be enough because there are very specific requirements under English law as to what is a valid submission. And there's a very good reason for that, my lord, because states should not, unless they're very clear and precise about the particular claims in respect of which they're waiving or submitting to the jurisdiction, it does not qualify for the purposes of Section 2.2.
Forgive me, I'm just struggling at the moment as to why anything is implied here. That's just using the words. Spain agrees with the United Kingdom that the United Kingdom shall recognise an award rendered pursuant to this convention.
My lord, the reason why I set out the way in which the argument was framed, and you can, you will see why I say it's implied, but let me just give you a preview. It's, as you saw, the words are inherent in, or it follows from. In order to be a valid submission under English law, and this will become clear when I take you through the cases.
I'm putting to you at the moment, what I'm trying to test at the moment
Yes.
is whether it's right to say it's inherent or follows from, and why it isn't simply the clearest express words between between a number of contracting parties.
Because
Spain is expressly not only submitting to it, but actually requiring the United Kingdom to recognise the award against it.
well, my lord, I disagree, because it would have to say, I, Spain, submit to the jurisdiction of England for the purposes of the enforcement of an ICSID award. It doesn't say that, which is why both parties say it follows from or is inherent in. And so the test for you is whether that is expressed or implied. When you look at the authorities, we submit, the conclusion to be drawn is that it is not an express submission, because the standard, the bar is very high. If you let me, and I will show you in Pinochet, my lord, a very similar argument was weighed, where it said that you have an obligation to prosecute torture. That must necessarily mean that immunity arguments can't be raised, because all the countries have signed up to that. And my lord, I'll take you to that.
Well, absolutely. I'm in no way suggesting this shortcuts the detailed arguments, but just trying to understand at the moment the starting point. And it seems to me that if A agrees that B will take an action to recognise the award, I'm not sure why that isn't an express agreement submitting to that being done.
Can I put it this way? In no way does that say that the state against whom the award is rendered has said we submit to the court's jurisdiction. It just doesn't say that. And when I show you the cases, you'll see that it does not satisfy the very high bar. There are some cases, my lord, where the words are even clearer than these, and they have not been seen to be sufficient by the Court of Appeal to be a valid submission. And my lord, I will be deserving all censure if the cases don't show you that. But can I take you through them? My lord, at paragraph 44, we have synthesized what the cases say qualifies an express submission to jurisdiction. Paragraph 44 of the Spain's skeleton. And my lord, I should add that this summary is consistent with Mrs. Justice Dias' judgment on what qualifies as a submission to jurisdiction under section 2.2. She explains that in paragraph 68 and 72 of the judgment. Now, my lord, the respondents don't deny that this synthesis correctly summarizes what the cited cases say. Rather, the respondents seek to distinguish these cases as not being relevant or applicable. They say you should also adopt the conclusion of the judge below that these cases are of limited relevance. And I will show those attempted distinctions do not work, and that these principles are what should guide you when assessing whether Article 54 is a submission to jurisdiction. I don't intend to take you through every case. I will focus on two key cases Spain say are especially relevant in demonstrating the approach on jurisdiction under section 2.2. And all the case I'll be spending most time on is R and Bow Street Stipendiary Magistrates, ex parte Pinochet 3. My lord, that's in the second bundle. tab 17, second bundle. And all this well-known case was about General Pinochet, whether General Pinochet was entitled as a former head of state to state immunity in respect of the allegations of torture advanced against him by the government of Spain. Spain argued that General Pinochet was not entitled to state immunity on two grounds. First, that the crimes committed were so horrific that an exception must be made to state immunity. And two, the crimes were against international law. And for such crimes, state immunity is not available. The immunity questions arose under Part 3 of the SIA, which deals with heads of state immunity. And the immunity in question was immunity rationi materiae, which is derived from the immunity a state enjoys and extends to officials' acts carried out on behalf of state by its functionaries. Now, by a majority, their lordships found that General Pinochet did not enjoy immunity. This was either because torture committed whilst in office was not an official act, triggering the immunity, or because the crime of torture was so serious and horrific that no immunity attached to it in the first place. Lord Gough dissented. He did not agree and found that General Pinochet did enjoy immunity. But I want to focus on that part of the case, my lord, in which all their lordships were unanimous. And General Pinochet's immunity was not removed because there was an implied submission to jurisdiction in the Torture Convention. On this issue of implied submission, Lord Gough provided by far the most detailed judgment discussion, taking into account international law materials, and his judgment on this point has been one that is much cited, including in the High Court of Australia, which I will take you to later in my submissions. My lord, I want to start by describing how the appellants want to focus. My lord, I want to start by describing how the appellants sought to argue that there was a submission to jurisdiction in the Torture Convention. What I hope to show you is that structurally, the argument on submission was very similar to the one that is now being made in both these appeals. First, my lords, can I just take you, in order to understand that, you need to understand the legislative or statutory background. So can I take you to internal pages 212, 213 of this judgment? Under the heading of the Torture Convention. You see there Lord Gough explaining that the essential purpose of the Torture Convention is to ensure, this is the opening sentence, second sentence, to ensure that a torturer does not escape the consequences of his act by going to another country. And if you move down to just below paragraph C, he gives a summary of each article. Article 1 defines torture. He notes that torture has to be inflicted by or be at the instigation or with the consent or acquiescence of a public official or other person acting in official capacity. Article 2 imposes the obligation on state parties to take effective measures. Article 3 prevents refoulement, return, or people to another state where there are grounds for believing they would be subjected to torture. Article 4 criminalizes torture by each state party. And Article 5 established the state's jurisdiction. It sets out the grounds for jurisdiction, and this includes acts committed in the territory of the state and where the victim is in your territory. And the last quote in the line above para F, where the alleged offender is in your jurisdiction. And Article 7 is concerned with the exercise of the jurisdiction, explaining that a state in whose territory an offender is found has an obligation to either extradite them or prosecute them in its jurisdiction. And Lord Gough then points out at line G, the proviso is directed at ensuring that torturers do not escape by going to another country. My lord, and the broad argument on submission based on these clear obligations to prosecute or extradite is discussed under the heading "The Argument" at page 213. Do you see that, my lord? And I'll read it, my lord, if I may. I now come to the second of the two issues which were raised during the hearing of the appeal, viz. Whether the Torture Convention has the effect that state parties of the convention have agreed to exclude reliance on state immunity ratione materiae in relation to proceedings brought against their public officials or other persons acting in an official capacity in respect of torture contrary to the Convention. In broad terms, I understand the argument to be that since torture contrary to the Convention can only be committed by a public official or other person acting in an official capacity, and since it is in respect of the acts of these very persons, the states can assert state immunity ratio non materiae, it would be inconsistent, my lord, and you remember those words were also used by the border party, I'll show you in a minute, with the obligations of state parties under the Convention for them to be able to invoke state immunity ratio non materiae in cases of torture contrary to the Convention. My lord, he then goes on to say that one of the ways in which this inconsistency could be cured would be to say torture cannot fall within the functions of a head of state, but that was a separate argument to the implied waiver one. But what he then deals with in this subsection, A and B, is the waiver argument, which is that the obligation to prosecute torture against public officials must necessarily mean immunity is waived, otherwise there would be an inconsistency between the Torture Convention and state immunity. And I pause here, my lords, because this is very similar, we submit, structurally, to what the respondents are arguing before you. As I showed you earlier, their argument is that given the obligation of state parties to recognize ICSID awards against states in their jurisdiction and to treat them like local judgments, it would be inconsistent with that obligation in Article 54 to allow states to invoke immunity and block enforcement. And it therefore follows, or is inherent in Article 54, the state parties must have waived or submitted to the jurisdiction in respect to enforcing awards. Any other conclusion would, you heard from the border timber parties, fatally undermine the obligation in Article 54 and would be inconsistent, in the same way as Lord Goff describes the argument before him. And the point to note is that Lord Goff treated the appellant's arguments that the obligation to prosecute in the Torture Convention necessarily meant that immunity had been waived as being an argument based on implied waiver. You will see this if you turn to the bottom of page 213 to 214. You'll see that, my lord, since therefore exclusion of immunity is said to result from the Torture Convention, and there is no express term of the Convention to this effect, the argument has, in my opinion, to be formulated as dependent on an implied term in the Convention. We say, and I will come back to this, that the same logic applies to the respondents when they argue that Article 54 necessarily entails a submission to jurisdiction. It is best characterized as an argument that there is an implied submission to jurisdiction in the ICSID Convention. And for completeness, I should add, my lord, that Lord Savile did seem to say that the Torture Convention contained an express waiver, but he was the only one who said that. The majority all agreed that there was no waiver, implied or express. And Lord Goff's judgment provides the most detailed discussion of implied waiver and refers to the international law position you must look at as well. So Lord Goff, my lords, then went on to explain why such an implied waiver was not permitted under the SIA. And I'd like to take you through that part of his judgment, as it reinforces the difficulties the respondents have, we submit, in presenting Article 54, or ICSID more generally, as containing an express submission to jurisdiction. My lord, Lord Goff's analysis begins at page 215. And you'll see there, my lord, the heading, waiver of immunity by treaty must be expressed. He opens by stating that he agrees that a state's waiver of its immunity must always be expressed. He then sets out the international sources supporting that statement. I want to highlight just the second one, which is the ILC's article on jurisdictional immunities, his lordship quotes at the bottom of page 215. A quarter of a way down that passage at G, you'll see it says, consent should not be readily implied. And then over the page, at page 216, line C, he synthesizes this and the other authorities to say this: the general effect of these passages is that in a treaty concluded between states, consent by a state party to the exercise of jurisdiction against it must, as Dr. Collins submitted, be expressed. In general, moreover, implied consent to the exercise of such jurisdiction is to be regarded as an added explanation or justification for an otherwise valid and recognized exception, of which the only example which is given is actual submission to the jurisdiction of the courts of another state. My lord, he then goes on to discuss the English law position, and you'll see that at page 216, line G onwards. He says that the provisions of the SIA are consistent with the principles I have already described. And then at the bottom of that page, and the top of the next page, he says section 2.2 and what the reference to a prior written agreement means. And it's this. Section 2.2, and this is at the bottom of page 216, recognize that a state may submit to the jurisdiction by a prior written agreement, which I read as referring to the express agreement to submit. There is no submission in the Act that an implied agreement to submit would be sufficient, except insofar as an actual submission to the jurisdiction of a court of this country may be regarded as an implied waiver of immunity. But my reading of the Act leads me to understand that such a submission to jurisdiction is here regarded as an express rather than implied waiver of immunity or agreement to submit to the jurisdiction. And then immediately following that quote, the Lordships will see that Lord Goss takes comfort from the fact that his conclusion on the need for an express waiver is also echoed in the Vienna Convention on Diplomatic Relations. The significance of this, my lord, and I merely note it, is that contrary to what the ISO parties tell you in paragraph 65 4C of their skeleton, that convention's requirement for an express waiver is one that does support and can be drawn on for construing section 2.2 as Lord Goff does. And my Lord Goff then ends this part of his decision by concluding at 217D in light of the foregoing, it appears to me to be clear that in accordance both with international law and with the law of this country, which on this point reflects international law, the state's waiver of its immunity by treaty must, as Dr. Collins submitted, always be expressed. Indeed, if this was not so, there could well be international chaos as the courts of different state parties to a treaty reach different conclusions on the question whether a waiver of immunity was to be implied. And my lords, I want to pause there because a warning about chaos is very much true when it comes to assessing the consequences of the respondents' arguments. For we now have a situation where you have before you two decisions of the High Court issued within 8 months of each other, having come to the opposite conclusion on submission, on whether there's been a submission to jurisdiction or not. Mr. Justice Fraser concluding that there was a qualifying submission in Article 54 for the purposes of Section 2.2, and Mrs. Justice Dias concluding that there was not. This is quite apart from the fact that the path adopted by Mrs. Justice Dias, that there was a general waiver and a submission and that these are two different things, is different from any other jurisdiction's conclusion. And then we have, my lords, a decision of Mr. Justice Wallbank in the BVI courts, where the SIA also applies in Tethian Copper in Pakistan. And you'll find that, I'm not going to take you to it, but you'll find that in
Well, I think
bundle
we should look at
6.
it actually because we're told it's 5 lines long.
Sorry, what was that, my lord?
We were told, I think by Mr. Green, that it's 5 lines long.
It is, my lord. That's why
I'd quite like to look at it actually.
sure, it's on
Since you
bundle
rely
6, my
on
lord.
And are we going to need Pinochet anymore?
I will be coming back to Pinochet, my lord, so I would ask you to keep it open.
Where's the...
It's, my lord, it's in bundle 6, page 86. Sorry, tab 86. Paragraph 51. My lord, it's in, have you got it there? It's A6, tab 86, page 3031, paragraph 51. My lord, as you'll see, I'm not getting into the detail of the reasoning here, just to show you that in this decision, another judge thinks that there is a submission, that there isn't a submission. Article 54 is not a submission for the purpose of section 2.2.
Give me which paragraph?
Sorry, it's 51, my lord.
51.
Yeah. I'm not suggesting that this sheds any light for your purposes. You need to do a detailed analysis. I'm going to take you through that. But all I want to show you is that the variation that has resulted, and I submit because the courts have not applied a strict test when it comes to what qualifies as a submission. But all the New Zealand and Australian judgments adopt yet different reasoning. They rely on different parts of the ICSID Convention to come to their view that there is a submission, and I'll take you to that. My lords, I say...
Doesn't this sort of undermine your starting point? Do you say, well, look, there's reference in Lord Goff's judgment to potential chaos?
Yes.
If court, you don't side with us, you get chaos. But it sounds as though you get chaos whichever route you go. Since plainly adopting your approach would not tally with all the other courts' approaches.
You're saying there's even fragmentation within the express waiver debate. My lord, I'm hoping that your lordships will clarify that, but I think that, that there is a far more dangerous sort of fragmentation if you have courts saying, applying that sort of lower bar, where you have no submission to submission, submission standard very high, and we think that there isn't one here, and that's really the arbitration exception. We would hope that this court, if it agrees with Spain, will make that clear. And I want to return to Lord Goff, if I may, because of his general remarks on implying terms into a treaty, the travaux préparatoire and treaty making. My lords, again, his warnings there about implying a waiver are very much relevant today in respect to the respondent's argument. Can we pick it up at page 218D? My lord, you'll see there an implication must in any event be rejected. If we can read the second paragraph, because it explains why one must be especially wary when seeking to imply a term into a treaty, as compared with the approach one takes to implying terms into a contract. My lord says, Lordship says, I recognise that a term may be implied into a treaty if the circumstances are such that the parties must have intended to contract on the basis of the inclusion in the treaty of a provision whose effect can be stated with reasonable precision, citing Oppenheim. It would, however, be wrong to assume that a term may be implied into a treaty on the same basis as the term may be implied into an ordinary commercial contract. For example, to give the contract business efficacy. This is because treaties are different in origin and serve a different purpose. Treaties are the fruit of long negotiation, the purpose being to produce a draft which is acceptable to a number, often a substantial number of state parties, and the negotiation of a treaty may well take a long time, running into years. Draft after draft is produced of individual articles, which are considered in depth by national representatives, and are the subject of detailed comment and consideration. The agreed terms may well be the fruit of horse trading. In order to achieve general agreement, the proposed articles may be amended or even omitted in whole or in part to accommodate the wishes or anxieties of some of the negotiating parties. And in circumstances such as these, it is the text of the treaty which provides the only safeguard to its terms. The reference may be made where appropriate to the travaux, but implied terms cannot, except in the most obvious cases, be relied on as binding the state parties who ultimately sign the treaty, who will in all probability include those who were not involved in the preliminary negotiation. My lord, I also put that down as a background, my lord, because in the cases that generally have considered this question, one sometimes thinks that there is not enough emphasis about the differences when one is trying to imply something into a treaty as compared to a commercial contract. And Lord Goff, in his brilliant way, he captures that one has to really pause carefully before undertaking that task. My lord, as in that case, a travaux has been considered here, and the situation with the travaux is similar, I would submit. in the situation here. What Lord Goff says is therefore instructive. If you turn to page 219E and the paragraph starting the danger, it's the second paragraph halfway down the page. The danger of introducing the proposed implied term in the present case is underlined by the fact that there is, as Dr. Collins stressed, Your Lordships, nothing in the negotiation history of the Torture Convention which throws any light on the proposed implied term. Certainly the travaux preparatoires shown to Your Lordships reveal no trace of any consideration being given to the waiver of state immunity. They do, however, show that the work on the draft convention was on foot as long ago as 1979, 5 years before the date of the convention itself. It is surely most unlikely that during the years in which the draft was under consideration, no thought was given to the possibility of the state parties to the convention waiving state immunity. Furthermore, if agreement had been reached that there should be such a waiver, express provision would inevitably have been made in the convention to that effect. Plainly, however, no such agreement was reached. And then, my Lord, it's the final part that is worth reading at page 221D. My Lord, and that is, I wish to stress, where he says, I wish to stress the implications of the fact that there is no trace in the travaux preparatoires of any intention in the Convention to exclude state immunity. It must follow, if the present argument is correct, first, that it was so obvious that it was the intention that immunity should be excluded, that a term could be implied in the Convention to that effect. And second, that despite that fact, during the negotiating process, none of the states involved thought it right to raise the matter for discussion. This is remarkable. Moreover, it would have been the duty of the responsible senior civil servants in the various states concerned to draw the attention of their governments to the consequences of this obvious implication, so that they could decide whether to sign a convention in this form. Yet nothing appears to have happened. There is no evidence of any question being raised, still less of any protest being made by a single state party. The conclusion follows either that every state party was content, without question, the state immunity should be excluded sub silentio, or that the responsible civil servants in all these states, including the United Kingdom, failed in their duty to draw this very important matter to the attention of their governments. It is difficult to imagine either of these propositions can be correct. In particular, it cannot, I suspect, have crossed the mind of the responsible civil servants that state immunity was excluded sub silentio in the Convention. My Lord, this passage is instructive to the present situation because I submit the same implications follow when one looks at the travaux in this case. There is no trace of any discussion of adjudicative immunity in the travaux. At para 30.2 of their supplementary skeleton, the Board of Timbers accept there was no specific mention of adjudicative immunity. The respondents' arguments entail you accepting that all the states believed that it was crucial and necessary for there to be a waiver, but never once discussed it expressly, and were happy for it to be inherent in the wording of the treaty without spelling it out. All the while, they implemented provisions elsewhere in the Convention on waiver of immunity with respect to ICSID, its property and assets, and that's Article 20 of the ICSID Convention. My Lord, we submit this is, and this would be, remarkable, and it's even more remarkable in this case because it is agreed that they did discuss and refer to another type of immunity, which is execution immunity in Article 55. So as Lord Goff said, this either means they were happy for adjudicative submission or immunity to be waived sub silentio, despite other immunities being spelt out expressly elsewhere, or that the civil servants did not discharge their duty and point out the waiver implications to the states. Well, we say both propositions are incorrect. Well, that's what I wanted to say about Pinochet. I wanted to take you to next.
In the paragraphs that you took us through, you didn't look at the top half of page 219. Lord Goff rejects the suggestion that in relation torture convention, it would undermine the whole purpose if there wasn't a submission. And he says, in the majority of cases, no question of state immunity will arise because the official concerned is likely to be present in his home country, and then no reason to assume it will be asserted. So I think the point is being made that it isn't obvious that the obligation in Article 7 of that convention is indicating an agreement to waive or submit.
All right. What I would say to that is just a few points. First is that what we draw from what got started at the beginning is, as I said, the structural point, which is how do you characterize an argument that says because X tells you to prosecute, or in this case, enforce awards, it necessarily follows that the awards against whom they're being enforced have submitted to the jurisdiction. He describes that as an implied submission. So whether it's inconsistent or not, we say we draw from that. The second point, my lord, is that everything I've taken you to, the force of that applies irrespective of irrespective of his view, his lordship's view, that it is inconsistent or not, about the dangers of implying. So once you accept that the structural way in which structurally the way in which the submission arises out of the Torture Convention is an implied provision or an implied submission, then what he says after that does not rely on inconsistency or not. It's simply dangerous, he says, and inducing of chaos to imply into a treaty a submission. And my lord, I would also submit to your lordship that it is not, it's something that, if I may just take a step back, of course we're looking at 2.2, but it is not inconsistent here either to say that there is a submission in 2.2, in 54, because there is the arbitration exception. And that's really the fallacy here, that if one looks at that part of the SIA, because it's either or, you can either show a submission or you can either show an arbitration exception. Just because you don't get to have a submission because of 54 does not mean your award is then not registered and enforced. The arbitration exception is there.
Why is it either or?
Because, my lord, under the SIA says that as long as you prove one of these exceptions, the immunity is removed. So you can either say, well, the immunity is removed because I have submitted by prior agreement. If that fails, you can say, well, there's an arbitration agreement here. So Spain has to succeed on both, whereas the respondents have to succeed on one in order to remove the immunity.
But you could remove immunity on both grounds.
You could, but if you've already decided, yes, you could, but you only need to prove one exception to remove immunity.
Yeah, but there's nothing that says that the exceptions to immunity in sections 2 to 11 are mutually exclusive, is there?
No, my lord.
But can I just, I appreciate that you moved on from the actual wording of Article 54, saying that the authorities would be the answer.
Yes.
But what I understand Lord Goff is making very clear here is that you cannot imply a submission.
My lord, I'm starting at a high level of generality, moving down. The reason why I'm doing that, if I can tell you the thinking, is because one can get into a rather philosophical debate, especially when you look at the High Court of Australia decision, of when they say that express can be implied, which raises the question, well, where does that boundary stop and where does a pure implied term arise? And what I want to show you is that if Lord Goff, for example, was looking at this, because I appreciate what one judgment says is an implied term, a different term may not be an implied term in another one, is that if we can at least get the ground rules right. Ground rule number 1, you need an express submission. This judgment explains why. Ground rule 2 is that what this judgment helps, I would submit, or is persuasive, is that structurally the same sort of immunity that's trying to be read into the Torture Convention is the one that's being read in here, and Lord Goff and the other their lordships, other than Lord Savile, characterise that sort of argument as an implied submission. And if you're with me on that, my lord, then that's it. because it's clear.
Can we just get one or two things out of the way?
Yes.
You're not suggesting, are you, that to have an express submission, you have to use the word submission?
My lord, I'm about to take you to a Court of Appeal authority that says exactly that.
Right, okay.
That's why I said I was just starting at a level of generality, moving down. That's okay. My lord, so can I,
Thank you.
my lord, can I then take you to, Lord, what I was going to then tell you was why the Pinochet case is helpful and not of limited relevance. My lords, as I said first, the waiver argument in Pinochet was structurally the same as the one made here. It was based on arguing that an obligation to prosecute, and in this case recognize an award, necessarily indicates that an agreement by states that they were waiving their adjudicative immunity. Lord Goff treated that as an implied submission. As I said, if you agree to that approach, then that would be fatal. His analysis of the international law materials and the danger of implying terms is also not specific to the Torture Convention. In fact, when he discusses it, torture is not even mentioned, it's general. So to say that he was just talking about the torture context is not fair. So my lord, let me come to the case that says submission is necessary, and that is Svenska and Lithuania. I'm going to start with Mrs. Justice Gloucester's unanimous decision, and then take you to the Court of Appeal that upheld her finding. And that's at the first bundle, my lord, tab 26.
Sorry, which tab? 56. Second bundle. That's 26.
Sorry, my lord.
Tab 26.
It's tab 26, second bundle. I apologise.
26.
My lord, you have it. I apologise for misleading you. My lords, this case arose out of an oil exploration and extraction contract between the claimant and Lithuania and the state enterprise, and a dispute arose about the right to exploit certain fields. The dispute was referred to arbitration, and Lithuania agreed that it was not a party to the arbitration agreement. The tribunal rejected this argument. The claimant then sought to enforce the award in this jurisdiction, and Lithuania sought to have the registration set aside on the basis of state immunity. My lords, I want to focus on Her Ladyship's decision on the claimant's case, that by clause 35 of the agreement, Lithuania had submitted to the jurisdiction and waived its immunity under section 2.2 of the SIA. My lord, can I just show you the clause? It's clause 35 at paragraph 24. Page 857. The governing law and sovereign immunity. Government and EPG hereby irrevocably waives all rights on sovereign immunity. And this agreement shall be governed by the laws of Lithuania, supplemented where requested by rules of international business activities, generally accepted. So my lord, 35.1 was being relied upon as a waiver. And at paragraph 26, the ladyship noted that the JVA, if you go to paragraph 26, my lord, its opening line contains no express submission to the jurisdiction of the English court. My lord, if you go to paragraph 28, you see her define the issues as they arise in respect of sections 2 and 9 of the SIA. At paragraph 29, she says the contract has to be construed under Lithuanian law in accordance with the governing law clause. I pause there, my lord, because in paragraph 65.6 of their skeleton, the ISL parties seem to be repeating their point below that this case can be ignored because it was construed under a different governing law, which is Lithuanian law. I can show you why this attempted distinction of Svenska is not correct. Yes, while Her Ladyship did construe the contract by reference to Lithuanian law. That is just to understand the meaning of the clause. If you turn to paragraph 32, you will see there that when it came to the question of whether clause 35.1 qualified as a submission under section 2, that was, as this paragraph puts it, a freestanding issue. And what she then goes on to say there, I submit, cannot be dismissed as a Lithuanian law conclusion, but one about how the clause in question would be perceived by the English courts applying their law to this clause, as the references to the English sources such as Dickinson shows you. My Lord, she then sets out her findings in paragraph 35. Onwards, I said. She says, my lord, her ladyship says, I cannot sensibly construe Article 35, which is purely a waiver of the state's immunity, as a written submission to the jurisdiction of the English courts within section 2.1 and 2.2 of the 1978 Act. And in the next paragraph, 36, she explains why the clause in A and X was different. I know there's a bit of jumping around, but I hope you'll see why I'm going to do that. I want to show you the clause in A and X because it's a contrast with what she believes is a qualifying submission and one that is not. And you can find that clause, my lord, in bundle 9. If you keep open, Svenska, I'm sorry to make you keep multiple bundles open, but if you turn to tab 158, bundle 9, well, the clause that she then refers to, and I'm going to take you to it, can be found at page 4730, bundle page 4730, and internal page 522. That's bundle 9, tab 158. You'll see, quarter way down it says clauses 6 and 7. Do you see that, my lord?
Yeah.
And it's worth reading so that you'll understand what her ladyship goes on to say. Sovereign immunity, clause 6. Remember, keep clause 6 in mind. The Ministry of Finance hereby waives whatever defense it may have of sovereign immunity for itself or its property, present or subsequently acquired. And then in clause 7, governing law and arbitration, this agreement shall be governed and construed in accordance with the laws of England without reference to the conflict of laws, and A&Co and the Ministry of Finance hereby submit to the jurisdiction of the English courts. Lord, if I could invite you to turn back to paragraph 36 of her ladyship's decision in Svenska. So when she refers to ACO, that's what she's referring to. And then her ladyship explains why ACO and X was different to the clause she was assessing. The difference was that in A and X, there was express wording by the state when it would say that the state submitted to the jurisdiction of the English courts. It wasn't just a general waiver in clause 6 that was enough. And you see that she explains that in paragraph 37, why general waiver does not qualify as an express submission under Article 2.2. If I may read it to you, my lords. So the third sentence, in the absence of any such submission in the JVA, it is, in my judgment, not only wholly artificial, but also wrong to say that a waiver of immunity, such as contained in clause 6, and there she's referring to A and X, can be treated as a consensual submission to the jurisdiction of the English court for the purposes of section 2 of the 1978 Act, simply on the basis that the state has under Article 35 agreed to waive all immunity points. She therefore dismissed the claimant's case that by Article 35 Lithuania had submitted to the jurisdiction of the courts under Article 2. The Court of Appeal did not disturb this finding or Mr. Justice Gloucester and Shidamore's analysis. Indeed, it endorsed it. And I'll take you to the short passage in the Court of Appeal decision for their reasons. You'll find it at tab 28. It's in the same. My lords, it's at page 975, paragraph 128.
Yeah.
My lord. She says about halfway down, it says, in our view, it is better to construe the contract as a whole. The judge was unable to accept that a general waiver of immunity of the kind found in Article 35.1 amounted to a submission to the jurisdiction of the English courts within the meaning of Section 2.1. We agree, not only because we think it is too imprecise, because we think it must be read into the context of the government's agreement to submit to ICC arbitration, which was in fact the context in which the waiver of immunity is found in the earlier parts of the agreement. My lords, I submit on behalf of Spain that 2 points emerge. First, the Court of Appeal agreed that a clause 35 was too general and imprecise to constitute a submission to jurisdiction under 2.2. And second, that this was reinforced by the fact that the contract contained an arbitration clause, which rather indicated that clause 35.1 was not designed to do the work of a submission to jurisdiction. That is what the arbitration agreement was designed to do. And that is really the message, my lords, to be taken here too in this case, because as I said earlier, submission to jurisdiction was never meant to be achieved by some waiver or written submission under Article 54, but by the arbitration agreement in the ECT that the states have agreed to under the relevant treaties. And I can see you have a...
Well, I am struggling a bit with this. The distinction being drawn here is between waiver of immunity and submission to jurisdiction. And the clause in ACO, which amounts to the submission, I think is
Clause 7.
7b,
Yes.
which doesn't use the word submission.
Well, it says submit, my lord. Well, my lord, can I put it differently? Saying I waive all immunity is not enough. And if that's not enough, then we submit that Article 54 is not enough.
But the question surely that has to be asked is whether or not 54 amounts to an agreement that the courts of, in this case the United Kingdom, shall have jurisdiction to resolve the matter in issue. And it's not, that's not a waiver of state immunity. It is an agreement that that each contracting state will have jurisdiction to register the award.
My lord, but it's not. But what the State Immunity Act tells us is that the rule is the state has immunity, and you have to show one of the exceptions apply. And one of those exceptions that is being relied upon here is show me a prior agreement where the state is submitting to this jurisdiction. And my lord, I'm sorry if I'm repeating myself, but our submission is that the requirements for a qualifying submission have been set very high, and that should not concern you here, because we are not saying that suddenly ICSID awards cannot be enforced and registered here, because really the mischief or the way in which you're supposed to remove immunity in principle is through the arbitration agreement. And I say that, my lord, because I said this earlier. What we are doing here, of course, we're talking in the ICSID context, but the test you place on what is a relevant submission obviously has far wider consequences. And as a matter of international and domestic law, the standards have been set high, because it should not be very easy to say, well, I find a submission here by the state. There has to be a very clear, precise submission to jurisdiction.
Yes, but we we see in the commercial court, we see clauses providing for submission to a particular jurisdiction all the time, and it may provide that the courts of England and Wales have jurisdiction, or any dispute shall be referred to the courts of England and Wales. Yeah. That is submission to the jurisdiction, isn't it?
It depends on if you're talking about two contracting parties, that's different. This is a state. This is a very, as the cases keep telling us, this is a very consequential decision to take jurisdiction over a state. And if the wording does not meet that standard, and even saying I hereby waive immunity generally is not enough, then
that isn't the wording here.
Well, my lord, my point on that is that
the question is, as I understand it, among the authorities you've shown us,
yes,
do the words of Article 54 mean that a state which is party to an exit award agrees to another contracting state, the courts of another contracting state have jurisdiction over that award?
so the argument being made is whether Article 54 means, and by the way, it's never been articulated what this submission is. It's just it must necessarily follow there must be a submission, because the submission is supposed to be, as it said on the other side, that Spain, for the purposes of enforcing or registering this award against Spain, Spain has submitted to the jurisdiction of this court for an action against it, because the enforcement and registration of an award is an action, and the court is taking jurisdiction over another state. And we say that 54 does not say that. It was never meant to remove the immunity. It's the arbitration agreement. And my lords, what I was going to do, and I can do it quickly now or after lunch, is when you actually see the tests for a relevant qualifying submission under 2.2 and then apply it to 54, it's very difficult to say that 54 is a qualifying submission under 2.2.
Let's do that at 2 o'clock.
Just before my lord rises, going back briefly to Svenska. I mean, waiver and submission are logically distinct, aren't they?
Yes, my lord. I think so. Yes.
Yeah, okay.
But I would say,
why
I
it's
leave
not
you
a
to this.
submission.
It's used unfortunately interchangeably, and somewhat loosely. But we can come back.
The argument was that the waiver amounted to a submission to the jurisdiction.
Yeah.
In circumstances where there was an arbitration clause.
Yeah. Which is the same here, my
An
lord.
express provision for Lithuanian law to govern the contract. So it wasn't a very promising start. So it was submission to the jurisdiction of the English court.
Perhaps, my lord, but that does not affect what she says, what her ladyship says, what the court as to
I
what.
understand. But it seems to me we're quite a long way from what we have to.
Well, my lord, that's not true. That's not true. We have an arbitration
Come back to
agreement
that
here
at 2
as well.
o'clock.
Yes.
Rise of people.